welcome back to the Planning Podcast from Number 5 Chambers for the autumn editions. And we're going to kick off straight away with an update, a case law update, looking at 5 cases decided in the period just before the summer vacation. 5 cases, mostly JRs, looking at how things are playing out in local authorities near you, and one DCO case too. So with Oliver Lawrence and Leanne Buckley-Thomson, both planning and environmental barristers at Number 5 Chambers, we turn straight to it. Well, it's September. We're here again, the Planning Podcast. Leanne, hello. Good afternoon to you.
Good afternoon to you, Richard. How are you?
I'm well. I'm very well. Very pleased to be back with you and back with Oliver too. Hi.
Hello, Richard.
Good. Straight in there. Case law update. Leanne, you've got 3 really good local authority cases, 3 JRs essentially.
I do.
Let's kick off with the really, really bad planning committee meeting.
Yes, well, I think we've all had our eyes open to committee meetings this year during the COVID pandemic, haven't we? And this is one case that I think anyone, whatever side you're on, will find quite useful. It's on the application of Save Walsash and the Western Wards. And we all know that one of the threads that runs through planning law, of course, is public participation. And it's really important that people are given a fair opportunity to have their say about the development of their communities. Richard, what's interesting about this case is that locals had been given an opportunity to comment, but the problem arose when only a few days before the planning committee meeting, the council uploaded a mass of further material from the applicant. Now, just rolling back a little bit, the application itself was to build 6 houses and garages on undeveloped grassland, which the applicant said should be considered lowland grazing due to use by horses, with a resultant 13 kilograms per hectare of nitrogen loss. Local residents strongly disagreed with that. In short, they said that the site was only grazed for a short period. And looking through the judgment, you'll see that one objector in particular said only 9 months over a 10-year period, so very short period, they said. But also that the nitrogen loss would be 5 kilograms per hectare for the part of the site not used for grazing in that period.
So a big scrap then
Yes.
this particular question, central to planning, how much nitrogen loss would there be by reason of the presence of the horses?
Absolutely. And so in the context of that, really, really important that the objectors understood what it was that they were responding to. And so when the additional material came in so close to the planning committee meeting, Richard, I'm sure you can understand why we then ended up in the position that we're in this case. In particular, the additional material that was submitted included statutory declarations in relation to the use of land for grazing horses, but also a licence agreement in relation to that grazing as well. So that's really where then it became even more contentious than it already was. And the objectors tried to deal with that, but they ended up having to apply for a deferral of consideration of the planning application because they said, look, we just don't have time to deal with it. And there was a suggestion from them that they would have prepared their own statutory declarations as well. So we find ourselves then at planning committee, and the chairman ultimately, and I do suggest people read the judgment because it gives a bit more detail than this, but the chairman ultimately suggested that the committee needed to make a decision that day. No member intervened and asked for the deferral to be put to a vote even, and the planning application ended up being approved. So a group of objectors brought a claim for judicial review. There were 8 grounds. I'm not going to go through all of those today, of course. What's really key, I think, for our listeners is the 2 procedural grounds on which the judicial review succeeded. In particular, those were procedural related grounds. And listeners will want to have a look in particular at paragraphs 36 to 39, 41 to 43 and 46 to 49 that go through those. In short, though the council accepted that it was a breach of statutory duty with regard to the late filed papers, they said, look, it doesn't make any difference the outcome. It would have been the same outcome anyway. But what the court said is, look, that's a really high hurdle to surmount. And listeners might be aware of the case of Joycey from 2014 and the Belfast City Council case of 2018, which in this case were applied by the court. Just a few headline points then as to the judgment. First, the chair's contribution and the members' acceptance of what was happening was plainly wrong. I'm sure listeners probably predicted that as I was going through the background. But actually, also that they completely ignored the objectors' position. The objectors were obviously prejudiced by it. The committee didn't grapple with the deferral application at all. They took a very high-handed approach. But also, as well, the possibility that the evidence that the objectors were saying would be put forward was capable of being countered or rebutted, that wasn't considered. The chair was concerned with delay, even though it wasn't the objector's fault. Clearly unfair. And it wasn't inevitable, the court felt, that focused representations made on the basis of statutory declarations by the objectors, when you looked at them with all of the evidence, would have resulted in the same conclusion. So although the objector's case perhaps wasn't as cogent at that stage, it was possible that a more cogent case could be advanced. So in terms of the teaching point, Richard, if I was to give one here, is to make sure, of course, that all councils and committee members think really carefully about objectors' representations, particularly the ability to deal with late information. It's so much better to err on the side of caution and just remember the really high threshold to overcome regarding whether or not the outcome really would have been the same.
Egregious unfairness, said the judge.
Yes.
Egregious.
Yes.
And so this is a great one, isn't it, for people to take along to committee if they are interested in making an objection. Keep this case in your bag, because you might want to wave it in front of whichever poor lawyer is looking after planning committee and say, no, really, this is late. I want a proper opportunity.
Indeed.
Might help you.
It might do. It's one for the planning committee poly wallet.
Thank you very much indeed for taking us through that so clearly and carefully. Oliver.
Yes, Richard.
I took my family to the ends of the earth, so it seemed, to see some standing stones. Have you got anything for us on standing stones?
Well, I do actually, Richard. And the good news is you'll be able to make such a trip again to see those same stones intact and unharmed. Because, as everyone probably knows, the High Court has allowed a JR brought by Save Stonehenge World Heritage Site Limited against a development consent order made by the Secretary of State for Transport, which gave consent for tunnel scheme on the A303, an 8-mile road project, which included 2 miles of tunnel past the Stonehenge and also within the World Heritage Site. So here we have a case where the Secretary of State, he allowed the scheme against the advice of a panel of expert planning inspectors who concluded that the scheme would cause significant harm to the integrity of the World Heritage Site against their advice. So the judicial review was brought under various grounds, and 2 of them succeeded, and they're both interesting just to examine because it would appear as if the claimants have overcome a pretty high bar, and the judgment was certainly rather critical of the Secretary of State's decision here. The first ground is that it was found that the Secretary of State made material error in law in failing to lawfully carry out the required balancing exercise, weighing the impacts on the significance of all the heritage assets affected, and indeed, of course, upon the Stonehenge itself. And so the judge found that the Secretary had not properly assessed the risk of harm to each heritage asset, finding that he simply did not have the evidence to conclude that the project would cause less than substantial harm to the heritage assets within the site. And that was fatal to the lawfulness of the decision to grant development consent. Pausing there, it's interesting to see the High Court weigh into the merits of such a scheme, because obviously the target of the claimants and the target of the judgment is the quality of the Secretary of State's decision-making process. But here we have certainly findings which have clear implications for how harmful the scheme was. Certainly that's the takeaway I think any reader would walk away with. And now further on, the second ground, which was successful, is also interesting for any lawyer, which was essentially that of irrationality. And the judge found that the Secretary of State acted irrationally, unlawfully, in failing to consider alternatives. And he found that the relevant circumstances of the present case were wholly exceptional. And so in this case, the relative merits of alternative tunnel options, completely material consideration, obviously material, the Secretary of State was required to assess them, and finding that it was irrational not to do so.
Really important decision. Findings of irrationality and findings in favour of claimants running alternatives arguments are pretty rare. And there's quite a lot of law to get over to get home on an alternatives argument. So I completely agree with you, Oliver, that is a very interesting example of an alternatives case actually succeeding. So the henges featuring again. My henges were in Scotland, in the Outer Hebrides, actually. And what struck me about those was that nobody seemed to care less about building housing around them. But there we go. I didn't suggest to the local inhabitants that they should have considered alternatives. Oliver, thank you very much indeed for bringing us up to date with the judicial review of a DCO. Let's switch back to Leanne, and let's come to affordable housing and a Section 106 agreement where Southwark were responding to a JR.
Yeah, so this is the case of R on the application of Flynn, and it's another interesting case, Richard, about how councils make decisions on applications, but this time in the context of delegated decisions. So here, the council's planning committee had already resolved to grant planning permission. It was for a mixed-use development in London, specifically the Elephant and Castle shopping centre, which some listeners may be familiar with. And that resolution was subject to the developer entering into an appropriate legal agreement. So nothing unusual here so far. And among other things, that agreement was to secure the provision of affordable housing. So again, nothing particularly unusual. So the planning officers and the developer then go off and they proceed to conclude their Section 106 agreement, and that's in line with the developer's affordable housing offer. However, it was varied to provide that where the west site provided build-to-sell units, up to a maximum of 15 additional social rent equivalent habitable rooms would be provided on the west site, with a commensurate decrease in the number of intermediate habitable rooms. So slightly different to what had been discussed. And as a result of that, a campaigner decided to apply for judicial review. That campaigner in particular was a campaigner for affordable housing provision, committed to ensuring that the 35% requirement for affordable housing would be delivered with every new development. And though his grounds were considered arguable, ultimately, spoiler, he didn't succeed. And it's for that reason that the matter found its way to the Court of Appeal. Now, the Court of Appeal then, Mr. Flynn's challenging Mr. Justice Dove's judgment in the High Court.
How very rude.
Yes, I know. So it's very well worth reading what the Court of Appeal had to say. But it's bad news for Mr. Flynn because ultimately he didn't succeed for a second time. So some of the key takeaway points I'll give you today, but again, I'd urge people to read the judgment. Are firstly, think about what the delegation allows you to do. And the reason why I say that is because here in this case, it was a clear and broadly framed resolution. It tasked the officers with the negotiation of what was termed an appropriate legal agreement. So with it being an appropriate legal agreement, if the negotiation didn't yield what the officers considered to be an appropriate agreement, then of course the Director of Planning was authorised to refuse planning permission. But otherwise, it could be granted and it could continue on as expected. There was no requirement that that legal agreement had to have specified terms, and there was nothing saying it had to be brought back to the committee for further consideration. So really key there then, Richard, that an appropriate agreement, not the most, no specification other than it needing to be appropriate. And that was the extent of what the resolution allowed for. And the court felt, therefore, that there was a possibility within that there could be several types of forms of agreement that would be able to be considered appropriate.
Okay.
And one wants to look at paragraphs 39 and 42 to 43 of the judgment about that. The second point then, Richard, to make is that you need to obviously think about whether or not your officer's judgment is rational in line with the report. That might be an obvious thing to say, but it is important to think about. And in this case, the court felt that it was rational for the officers to take the view that the agreement would still ensure the delivery of the proposed affordable housing as expected by the report. So it's a very obvious point, perhaps, but one that shouldn't be lost nonetheless. And then the final point to make is, of course, there was a fallback position here in terms of the type of affordable housing that was expected to be provided. And the court says here, look, with any fallback, you need to think about, even if it's not the same thing, is there a significant difference between the things? So what do I mean by that? Well, here, social rented housing was one of the things, social rent equivalent was the other. And although they're not the same, there wasn't, the court felt, any significant difference in the circumstances of this particular case between those two things. Both types of accommodation had security of tenure continuing in perpetuity. there was only a tiny proportion of affordable housing in the development that would be provided as social rent equivalent in the fallback situation anyway. And the court felt that Mr. Justice Dove would have been aware of that when considering the differences and whether those differences would realistically have meant that the advice was effectively negated or invalidated the delegation in any way. So just a few helpful points there then, Richard, for councils, but also actually not just councils, those on the other side to consider as to whether or not the process is one that has been carried out appropriately.
And so, rather like your previous case, where you're at committee, you're taking along in your plastic wallet key cases, that the thing to keep in mind here, I think you're saying, is just be careful about how the resolution is made.
Yes, absolutely.
So when it's all fired off for officers to think about later, pay close attention to what scope of discretion the officers are being given, because that might all unravel later.
Absolutely, and certainly for Mr. Flynn in this case, and hindsight's a wonderful thing, isn't it? But for Mr. Flynn in this case, if you've got a particular, bugbear or a particular point that you really want to make sure is followed through, making that point at the committee, look, you need to be thinking about the wording that you're including here, because this is what I want.
Got it.
Absolutely.
Excellent. Thank you very much, Leanne. Now, there, the claimant was Flynn, and he was going to pay 2 lots of costs. If it had all stopped early on, then the only question would have been whether or not he was paying acknowledgement of service costs. But in any event, if there's an interested party, this is often a problematic question. Interested parties' costs in a judicial review. Does the Supreme Court care less about costs, Oliver?
Hard to say, Richard, but currently it could be still costs for all. Here we have the case of CPRE Kent against the Secretary of State for Communities and Local Government, and the sole issue that the Supreme Court had to determine was whether a claimant in a JR, if they're unsuccessful at the permission stage, of course, it's normal that the loser pays the winner's costs in this country, but should they be liable for the costs of multiple other parties, including interested parties? Well, the answer to that is still yes, because those are essentially rules which were set by the appellate courts, which the Supreme Court did not wish to disturb. The background is CPRE. They challenged an employment allocation policy in the local plan of Maidstone Borough Council. They challenged its adoption, and their claim fell within the scope of the Aarhus Convention. And as a result, they obtained protection against an adverse costs award by means of a £10,000 costs cap. Well, the claim did not succeed. In fact, permission was refused, and they were ordered to pay £10,000 split amongst the Secretary of State, Maidstone Borough Council, and the developer. And it would appear that the £10,000 cap, although pretty handy, that brought CPRE limited comfort, because they appealed and they argued that they should not be liable to pay more than one set of costs. They made various arguments, which look very thorough and very well prepared. They referred to House of Lords case Bolton Metropolitan District Council against the Secretary of State for the Environment, where the House of Lords gave some guidance to the effect that where you have multiple representation in a planning appeal, the losing party will not normally be required to pay more than one set of costs. So CPRE argued that there's no justification for adopting a different approach at the stage of the permission hearing. And they made some policy points as well. They argued that departing from a general principle to award only one set of costs has created financial uncertainty for claimants. It's resulted in interested parties making large claims for costs, and on occasion the court has had to raise the Aarhus cap to accommodate a claim for costs by an interested party. So they made their policy arguments, and the Supreme Court heard them. But ultimately they said, this is, I'm afraid, a matter for the Court of Appeal. It's not for us, because the cost principles laid down by those courts are described by the Supreme Court as matters of practice and not matters of law. And they said that only in the rare circumstance of an appeal on costs raised a question of law of general public importance was it appropriate to appeal to them. And they're not concerned with the question of the application of practice rules to the facts of the case.
Well, there we have it. Supreme Court essentially leaving it on the Court of Appeal's desk and deciding not to go along and pick it up. Thank you very much indeed, Oliver, for that. Interested parties, frequently developers, but also quite often local authorities, really do need to pay attention to that in terms of their potential to pick up costs in 288 and JR proceedings. Thank you very much. Now, this brings me back to Leanne.
Yes, and Richard, I couldn't let today go by without including an enforcement case. I love a bit of enforcement, I have to say.
Quite right too.
And this one's particularly interesting, although of course I would say that. And it's the case of R on the application of Ocado Retail Limited. It involves Islington Council. And, you know, again, I know I keep saying it, Richard, but I really recommend that the listeners take time to read the judgment, and particularly for this case, because we all know enforcement can be tricky at the best of times. But we will try and put it as simply as possible. And this is a matter that concerned a terrace of 4 units on an industrial estate that had been built following a planning permission granted in 1984. Within those conditions, the units were required to be in light or general industrial use only. Condition 3, you'll hear that come up again, and not as warehousing. So there then followed the acquisition of the units with other property in 2002 by Telereal. The units were leased back to BT by them, and then in 2014 leased to Royal Mail. So there's a couple of changes of hands there. And the important point is that until 2017, those units were used as a distribution warehouse. When that lease ended, Telereal marketed the units as Class B8 storage and distribution, and they applied for a Clwyd. Now, in doing that, what they said is, look, this use began all the way back in 1992. Yes, it was in breach of Condition 3 to the permission, but, you know, it's been for such a long time now that we are therefore entitled to our Clwyd. They said that the units combined constituted a single planning unit in order to justify that proposition. And they said that once they had demonstrated that 10-year period from 1992, the use hadn't been lost, even if it wasn't then continued further. Now, a Clwyd was granted by the authority, and the units were then leased to Ocado. However, unhappy news for Ocado, because the Clwyd was then revoked.
Oh no!
Revoked by the local planning authority under section 193 subsection 7. And the reason for that was that the local authority said, look, there's been material false statements here. There's been material information withheld as well. And sorry, we can't now continue to allow that Clwyd to stand. They said that the application and the decision had proceeded on an incorrect legal basis, that being that the issue was whether...
Send back.
Yeah, I know, exactly. And bad news. They said, look, what we were looking at was whether there'd been 10 years continuous use at any time in the past without it being abandoned or suspended. But actually, the law requires, they said, the law requires the breach to have continued for at least 10 years up and including the date of the application for the Clwyd. And we'll find out if that's right in a minute. They also argued that they hadn't been provided with an accurate factual account of the use, that should have been provided, and that had it been, that would have flagged to them that they needed to investigate further. And if they'd done that, there might have been a different decision. So there's a lot in that to unpack, of course. And the claimant, Ocado, said, no, we're not standing for that. We're going to apply for judicial review. And they did.
Thank you very much indeed, Leanne. Thank you very much indeed, Oliver. You're such top case law reviewers. We'll have to get you back, perhaps just before Christmas. See what's happened by then. If I can tempt you to do that, that would be great. So, Oliver, thank you very much indeed. Have a great evening. Goodbye.
Thank you, Richard. You too.
Leanne, thank you very much indeed for that, and have a great evening.
Thank you. You as well, Richard.
That was a planning podcast from Number 5 Chamber. We'll be back again soon, bringing you what's happening during the course of the autumn and turning to topical areas of planning law and planning practice. Until the next time, goodbye.